Lord,
Yes.
may I have your lordship's kind leave not to mention a matter as to be mentioned, to appear as to be mentioned.
Why?
Lord, this is a partition suit. Your lordship would recall your lordship had directed to direct the matter to appear on 9th of April. Lord, for filing of the written notes. Lord, we had filed, only the plaintiff was Lord, to file. Lord, on 9th of April, Lord, it did not appear. Lord, so it may appear as to be mentioned just for filing written notes so that your lordship can make it see.
Lordship, may I have your lordship's leave to
Upon
mention?
notice, I was mentioned.
I'm appearing as a complaint.
Lordship, may I have?
Has to be mentioned written notes.
Oh, yes.
Yes.
Lordship, I'm mentioning CS.Com number 39 of 2025 by order dated 2nd of April 2025. Lordship had admitted the plaint and had granted leave under clause 12. However, in the order sheet, there's a spelling error in the name of the plaintiff. And one more error is that it is recorded that the plaintiff is currently within jurisdiction. However, the plaintiff has recently changed his registered office. And at the time when the cause of action had arisen, he was within jurisdiction. So this has to be corrected in the order admitting the plaint. Kindly keeps it at to be mentioned. Great.
With your lordship's kind leave, may I mention 3 matters? It's CP number 1, 2, and 3. These matters were listed on 10th of April and it was supposed to be listed today as per the last order.
CP number.
Yes, your lordship. Company petition 2 of 2025, 3 and 1 of 2025. I have the orders with me, your lordship. I'm mentioning upon notice.
Company matter is taken only on Wednesday.
Your lordship, we are enjoying
By which
interim
order?
order in this matter.
Huh?
The interim order is expiring today, so I'm requesting that this interim order may
Which
be
for the other side?
ROC is for the other side, your
Huh?
lordship. ROC.
Have you informed?
Yes, your lordship. We are mentioning
the
upon
notice?
notice.
Where is the notice of mentioning?
Yes, your lordship.
Company वाला भेज देना. Come at 2. Again inform the other side.
Yes, your lordship. I'll do that. Obliged, your lordship.
Your lordship, may I be permitted to mention a matter to come as to be mentioned? This
For
is
what?
for correction of order, your lordship.
Huh?
Correction of order.
Which order?
Your order dated 16th April 2025. There's a small correction in the order in the second page, your lordship.
Your lordship, may I be permitted to mention GA4 of 2024. Your lordship, and the same has been disposed of on 18 Feb 2025. Your lordship, I am under instruction to file an appeal. All I am praying for draw up and complete the order dated 18 Feb 2025.
May I have your lordship's leave, my lord, to mention a matter which is running in your lordship's list. Item number 83, my lord, of commercial list. The matter, my lord, in nutshell is we are only seeking for directions in terms of section 24A of the Commercial Act for time management of the proceedings, my lord.
80?
83 of your lordship's list, today's list, my lord.
What is the number?
My lord, it's CS.Com number 818 of 2024.
Who is for the other side?
My lord, the other side in this matter has not been appearing, my lord. There are orders to that effect, my lord. So if the matter can be fixed on any day, we can just.
Nobody is appearing. How the case management will do? It is to be first. It has to be go for the undefended suit.
My lord, if your lordship.
How it can be the case management?
Your lordship will kindly take up order of 2nd December, my lord. In this second pata touch. Actually, my lord, this was before a coordinate bench, my lord, of Justice Patnaik, where Justice Patnaik had asked us to serve the notice intimating that the matter would be appearing to the other side as well as the party itself. We have communicated the notice. Even after that, they didn't appear. So the matter was then converted into commercial determination, and after that, my lord, the directions were supposed to be passed. Actually, they have filed a written statement, my lord, so possibly it can't be made as an undefended suit.
So Have you taken, you are for the plaintiff?
Yes, my lord, we are for
After
the
the conversion, what steps you have taken?
My lord, after conversion, the matter had appeared, my lord. So we
You
had
have to
sought
take
for
steps with regard to the statement of truth, with the amendment.
those
and
things have been completed, my lord.
How it has, how it
My
has
lord,
been completed?
there are orders to that effect. That's how the suit was converted into CS commercial and number was put.
No, where is this mention you have complied with the provisions of the Commercial Court Act after the transfer? After the transfer, you have to take 3 steps. First, you have to amend the cost title of the plaint.
My lord,
Second,
those
you
have
have
been-
to file the statement of truth.
those
Third, you
have
have
been
to
done,
file
my
the affidavit of documents in terms of amendment rules, order 11, rule 1,
My lord,
6,
those were being done,
4,
my lord.
6, all these things.
My lord, those were being done because there was also a report which was called in by the registrar original site, in which the registrar original site had mentioned that the writ of summons was served originally, but the defendants have chosen not to appear. In that circumstances, if your lordship wishes, my lord, we can intimate them once again whenever
You
this
do
matter.
one thing. Parso, to be mentioned.
My lord, should we mention the defendants one more time, my lord? The matter would be
Yes,
taken.
issue the notice to be mentioned. It will be listed day after tomorrow.
Grateful,
If
my
they will come, then I will see the record.
lord. We'll do that, my lord. We'll do that.
My lord, may I
Yes.
Have my lord's kind leave to mention an undefended suit. My lord, it is today appearing as item 110 of my lord's list. The matter, my lord, was fixed for arguments on 11th of April at 3:45 p.m. But my lord did not sit that day. Thereafter, the matter has been appearing normally in the list. My lord, be it my lord's pleasure to fix any day for hearing. Only arguments remain, my lord. Witness action is complete. May I hand over a copy of the last order?
Argument time है कोई? मैं 340. Come in June.
As my lord pleases, any day in May or June, as
May,
is.
because I don't think from second week this court will not be available in the circuit bench.
In that case, June, lordship.
9th June,
9th.
first day.
Lordship.
Record, yeah, क्या list है? Which seat
Item 110 of my lord's list today.
Item number 110. No, advocate appearing for the plaintiff has mentioned the matter and submits that the matter was fixed on 11th April 2025 at 3:45 p.m. for argument, but due to non-availability of this court on the said date, the matter could not be taken up for hearing. In view of the above, police stop. The learned counsel for the plaintiff prays for fixing the matter for argument on a specific date and time. In view of the submission made by the counsel for the plaintiff, let the matter appear on 9th June at 3:45 p.m. for argument.
Deeply.
My lord, may I be permitted to mention one matter, my lord? My lord, this matter was appearing in my lord's bench, but after the change of determination, it has been transferred to court number 23, my lord. But the Honorable Justice Arindam Mukherjee has, due to personal grounds, he has released the matter, my lord. My lord, I have already
Which
submitted.
matter?
My lord,
IFA matter, Indian Football
Huh?
Indian Football Association, my lord. My lord would recall that my lord has already.
Release it, but I cannot automatically fix the matter before this court. You have to get it assigned from the Chief Justice.
My lord, I have already submitted one letter to the Honorable.
Let matters assigned here.
No, my lord.
Let the assigned list come. If it is list, assigned list will be published, then you mention. I will take
Grateful.
that. Commercial division. Convention item number 1. Yeah, exhibit 5. Yes.
Your Lordship, I had mentioned this matter last Thursday, Your Lordship, for appointment of a new advocate commissioner, Your Lordship. As per Lordship Vivash Patnaik's order dated 26th March 2025.
What you submitted?
Your Lordship, an advocate
What you
commission.
submitted what? You have put the name, but you have not.
Honorable Justice Vivash.
Yes, you have not submitted the Honorable Justice.
Oh, I apologize, Your Lordship. As per Your Honorable Lordship's Vivash Patnaik's order dated 26 March 2025, Your Lordship had appointed senior advocate learned senior advocate Aniruddha Mitra as the advocate commissioner, Your Lordship, but subsequently due to his busy schedule, he has denied, Your Lordship. So a new advocate commissioner needs to be appointed, Your Lordship.
I am not objecting to this.
Your Lordship, may I mention another small correction, Your Lordship? In the second page of His Lordship Vivash Patnaik's order, Your Lordship, there is mentioned in the Your Lordship, it is mentioned in the third paragraph in the second page. The remuneration of the learned advocate commissioner is fixed at 3,000 GMS to be paid by the plaintiff at the first instance. Subsequently, it is also mentioned in the second last paragraph, the aforesaid expenses shall be borne by the plaintiff / applicant. Your Lordship, just kindly include the term at the first instance at the second last paragraph itself.
How many witnesses you are having?
Only one currently, Your
You
Lordship.
will also adduce the witness.
Yes, Your Lordship, but we haven't prayed for examination before the learned commissioner yet. We are yet to take instructions on that, Your Lordship. This the learned commissioner was only appointed for the examination of the plaintiff's witness.
So appearing for the plaintiff, so appearing for the defendant. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. By an order dated 26th of March 2025, this court has appointed Mr. Aniruddha Mitra, learned senior advocate from a Bar Library Club, as commissioner for examination of the plaintiff witness number 1, namely Mr. Prabhir Kumar Shah. Counsel for the plaintiff informed this court that Mr. Aniruddha Mitra, who have been appointed as commissioner to recording the evidence of the plaintiff witness number 1, is not in position to hold the commission for examination of the witness on commission, and as such, learned counsel for the plaintiff prays for change of advocate commissioner. Learned counsel for the defendant has raised no objection. Accordingly, in terms of as per the prayer made by the counsel for the plaintiff in place of Mr. Aniruddha Mitra, learned senior advocate. Yes, you can do that. You're not so and so. Give the name and number. Both party ready? Any objection? So appointed as commissioner for examination of the plaintiff's witnesses on commission. Fully stop. By an order dated 26th of March 2025, this court has already fixed the remuneration of the commissioner as at 3,000 GM at the first instance. Let the same be continued. The final remuneration shall be decided at the time of filing of the report by the commissioner. The commission is directed to inform the date of commission. When you will file the affidavit in examination chief?
Your Lordship, the examination in chief was already, it has already been filed.
Yeah.
It is in
court.
Yes, Your Lordship.
The advocate, the learned commission is directed to inform the hearing of inform the examination of the witness on commission to the assistant registrar of this court, so as to enable the official of this court to produce the documents before the commissioner at the time of examination of the witness. The commission is directed to complete the examination of the plaintiff witnesses. Examination of the plaintiff witness within a month from date, and to file the report before this court. Today we are on 21st, na? Before this court on 10th of June 2025.
Your Lordship kindly includes that it shall be paid by the applicant plaintiff in
This
the
makes
first.
clear that the commissioner is appointed on the prayer made by the counsel for the plaintiff. Accordingly, remuneration of the commissioner shall be paid by the plaintiff only.
First.
Good.
Grateful. Your
To the above extent, the order dated 26 March 2025 is modified. Okay. Yes.
This is my plan. First time appearing, court fees on suit value has not been paid. So allow me to pay court fees and suit value.
Court fees not paid.
Not
Then
I'm saying leave to pay the court fees is on the basis of the total claim.
what is the mention? Where is the again the same thing has been done.
That is
50,000.
My lord.
What you want to correct this?
Leave to correct this.
What? Valuation.
Paragraph valuation.
Paragraph 24.
24.
And what is the total value?
Total value is 70 lakhs 2,353.
And this should be a 50,000 as a court fee.
My lord, that's wrongly done.
So appearing for the plaintiff. The matter is listed as under the heading presentation of the plaintiff. The counsel for the plaintiff submit that at this stage the plaintiff is not intending, not praying for any leave under order to rule 2 of the CPC. Full stop. The counsel for the plaintiff also prayed for leave to correct the valuation of the suit in paragraph 24. That let the said correction be made within a week.
Yes, week.
Within a week. After the correction, let the matter appear on 29th April for presentation of print under the same heading.
Get put to lodge.
Yes.
Lordship, this is a plaint for recovery of dues against goods sold and delivered by the plaintiff to the defendant. Sufficient court fees has been paid. I'm seeking leave under clause 12 of the letters patent, as the defendant is outside jurisdiction of this honorable court, but the plaintiff is within jurisdiction. Goods were sold from here, invoices were raised from within jurisdiction, and payments were received here. Also, Lordship, there is a settlement of accounts and reconciliation of accounts, which was also carried out within the jurisdiction of this honorable court, and the document is annexed at page 204, Lordship, volume 2 of the plaint.
Just a minute. Just a minute. When the last payment was made?
Lordship, 16th of January 2021. Lordship kindly takes the ledger at the last page of volume 2. The last date of payment is the last entry.
Yes.
16th of January 2021. Thereafter, Lordship, the plaintiff relies on the order of the Honorable Supreme Court suspending limitation up to the period of 28th of February 2022.
15 January, 15 February. Last
Lordship,
payment was made?
16th January.
16 January.
Lordship kindly takes the ledger.
Yes, 16 January. 1,10,000.
11 lakhs.
11 lakh. Yes.
Lordship, thereafter, the period of limitation was not being calculated till 28th of February 2022, and parties were involved in the mediation, pre-institution mediation.
Mediation was initiated.
Lordship, it was initiated on
September
27th of
24.
November
September
2024.
24.
Yes, and it concluded in a non-starter report on 14th of January 2025. So, Lordship, I prepared this chart.
January 25.
Yes, because Lordship, the defendant had initially indicated that they wished to participate in the mediation. The parties were then directed to submit the cost of the mediation, which the plaintiff did. The defendant did not pay its side and then further submitted the response that it does not wish to participate. So therefore, the mediation
So
was
September, when the first notice was issued, because minimum 5 months, maximum 7 months, 5 months the mediator is having, whether it was extended with the consent of the parties.
Lordship, 27th of September is when we filed the mediation. Thereafter, the first notice was issued. And the dates exactly I have not annexed with the plain because those were not relevant
So
for the...
September, October, November, December, January, February. More than 1 year.
No, Lordship. 27th of September 2024 and 14th of January 2025. It's 4 months.
Okay. Okay, so your last payment was made on
16th of January.
16 January 2021.
Lordship.
Correct. So your limitation 3 years.
3 years from 1st of March 2022.
Why?
Lordship, because this comes under the exclusion period.
In the exclusion
Yes,
period.
yes.
Yes. So,
So
first of
from
March 2022
till 1st of March 2025.
Correct.
And 4 months of the mediation period as per the proviso to section 12A of the Commercial Code Act.
Okay.
So, Lordship, we have 73 days pending in limitation.
Okay. Plaintiff is outside.
Plaintiff is within, defendant is outside.
Census and suffering for the plaintiff, census and suffering for the plaintiff, full stop. The matter is listed as mess and the matter is listed under the heading presentation of plaintiff. Full stop. The plaintiff has filed the present suit, praying for a decree for a sum of rupees 63,37,332, along with interest at the rate of 18% per annum. Full stop. The plaintiff has prayed for leave under clause 12 of the latest patent 1865 and submit that the plaintiff is within jurisdiction of this court, but the defendant is outside the jurisdiction of this court. And as such, part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Consider the submission made by the counsel for the plaintiff, peruse the materials on record. This court finds that the plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent is granted. Plaintiff is admitted, subject to scrutiny by the department.
Okay.
May it please your Lordship.
Yes.
Your Lordship will recall this is the matter where our letter of credit was issued. And we had also filed an injunction application. Your Lordship was pleased to grant us an injunction. Lordship's last order dated 25th March, your Lordship had issued some directions. It issued, we have served the defendant number 5, the HDFC Bank, which is our negotiating bank. They had not received a copy of the application. And I believe my learned friend is supposed to file his wakalatnama too.
Your Lordship, we have
I'm led by
received the letter of authority. The only issue is with regard to the affidavit of competency and the wakalatnama, which has to be supposedly through the High Embassy of the Bangladesh High Commission, your Lordship. Now I am submitting upon instructions, although your Lordship, I must acknowledge that I do not have any documents that the client was, the defendant could not travel because they could not, their visa was rejected, which is why they could not come to Kolkata, to India, to get this affidavit of competency affirmed and endorsed by the Bangladesh High Commission, your Lordship. But your Lordship, I leave it up to your Lordship because I do not have any documents to support that.
So if you're not filing the wakalatnama,
so your Lordship, all I am praying before your Lordship now, if your Lordship kindly gives me the leave to file this letter of authority and the affidavit of competency, which is affirmed by them, but without the endorsement of the Bangladesh.
Don't how it can be.
Very well, your Lordship.
Yes.
But as far as our plaintiff is concerned,
Defend number 2.
Yes,
yes,
your lordship.
they are the main bank, my lord, the issuing bank. My lord, as far as the plaintiff is concerned, your lordship had allowed us to carry out the corrections in the plaint. That has been done. My lord, we have also made an application before the master, I believe, for extension of time to, my lord, reissue the writ of summons. Yes, my lord. So, my lord,
Let the writ of summons be issued.
yes, yes, my lord, let it be issued.
I am extending this.
Yes, my lord, kindly extend it. For the problem. 25th, it is expiring. Kindly, if your lordship extend it
for
till
the plaintiff.
June.
So appearing for the defend number 2. Counsel for the defend number 2 submit that though by an order dated 25th of March 2025, this court granted leave to the defend number 2 to file wakalatna within 2 weeks, but the defend number due to rejection of the visa from Bangladesh, the defendant number 2 could not reach India, and as such it is not possible reach India, and as such it is not possible for the defendant number 2 to file wakalatnama as well as affidavit of competency. He submit that the affidavit of competency has been notarized.
No, your lordship.
Competency has been
Notarized by from Bangladesh.
Notarized from Bangladesh, but it has not been apostilled by the Bangladesh High Commission, and as such it is not possible for the defendant number 2 to file the same in the court. To counsel for the defendant prays for time so as to enable the defendant number 2 to file wakalatnam as well as affidavit of competency. So counsel for the plaintiff submit that he has carried out the defects in the plaint, and he has also filed an application before the master for issuance of writ of summons upon the defendants. In view of the above, time to file wakalatnam and the affidavit competency by the defendant number 2 is extended for a further period of 3 weeks from date. Full stop. The counsel for the plaintiff submit that the interim order granted delay is going to be expired on 25th of April 2025. Accordingly, prays for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 10th of June 2025. Let the matter appear on 10th June 2025.
This is my application for appointment of advocate commissioner, my lord, for recording evidence.
But I appeal for the insurance company. But what instruction I have already told my learned about it. He's better acquainted than me because he very often appears for the government. Now, my instructions are this to both of us.
So
that pray.
So plaintiff will insure the insurance company.
to me and my but the opposition is this, that we want to. They have
order of court.
That they want to use an affidavit objecting to that. That's why.
What affidavit?
What affidavit? See, plaintiff's witness. I will appoint the commissioner. They will pay the remuneration
of course we will pay
commissioner
to him. So
yes.
far as is concerned, we don't know whether we'll pay for.
You are not final. Let us see what.
May tell you, Lordship. Otherwise, if your Lordship looks into this petition itself, but there's no ground for really appointing a commissioner. More than that, I am suffering. I have a pacemaker implanted 1 year back.
It's more than
I have a pressure is more than that. Then I need not have to come to court. In that event, Lordship permits me virtually all the time, because I have
this
the pain.
has no
MySpace doesn't
for virtual.
For the pain where MySpace
is allowing all the advocates who is interested to participate to virtual, no problem.
That's your Lordship really permits.
Well, about 400-page documents, 2 witnesses.
Do one thing. Or I am keeping tomorrow, day after tomorrow, no problem. You take the instruction from your insurance company. I will appoint the commissioner. They will bear all the fee, commissioner fee with regard to the examination of the plaintiff witness on commission. With regard to your witness, we'll see if you are interested to examine, or otherwise we'll see to what can be done.
No, one witness they have named. Another witness there is no name.
I will examine. As per, if they will examine I will, because I am fixing the commissioner fees as per the sitting.
Lordship. Well, in junior stage, this used to be the subsistence allowance.
Correct. That's why.
No, that's
the
correct.
sitting, because
Absolutely
sometimes what's happened, the court fix a remuneration and the parties takes time, then the commissioner will be frustrated.
It is better per sitting.
Per sitting, it will be
Yes,
better
ma'am.
for the
Lord, Lordship.
You take instruction, you will not be harmed.
Fine.
You will not be harmed. And the commissioner, where is the
Difficult-
witness?
The difficulty is this, Lord.
Here only.
What I'm being told, Lord, we don't know how to go there, who will be
Where
the
the witness
expenses.
will examine.
So for our expense are concerned.
I mean, within High Court area,
The High Court area.
there are a couple of halls
There
available.
are so many.
Very well to try to convince them.
Yes, that's why I am
Difficult to
giving
make
2 days time. Come
Difficult to
day
make
after
High
them.
Court
tomorrow.
area.
Come day after tomorrow, they will examine the witness in the High Court area only. They will not go to the other district for examination
No, no,
of the witness.
Lordship keeps it. I'll try to convince them.
Day
That's
after
all.
tomorrow, I am fixing it.
Day after tomorrow.
So and so appearing for the plaintiff, so and so appearing for the defendant. The plaintiff has filed an application being GA Com 5 of 2025 for appointment of commissioner for examination of the plaintiff witness. Police. The counsel for the defendant raised for time to take instruction. According the case is returned, let the matter appear on 23rd April under the same heading.
Day after tomorrow, Lordship.
Same.
Yeah.
I appear for the defendant, my lord. On
Bearing on behalf of the petitioner plaintiff, Your Lordship, this is my application under Order 13A, Your Lordship. Your Lordship, I'm being led by my senior. However, due to his personal difficulty, he could not, is not available today. I'm praying for adjournment today, Your Lordship, any day, subject to your convenience and to my learned senior.
Affidavits completed.
Lordship, principally affidavits are complete, but on the last occasion, my
Yes, Your
learned
Lordship.
friend appearing for the plaintiff took leave to file a supplementary affidavit.
We
My
do not
lord,
wish to, Your Lordship. No,
You
we
will
do
not
not wish to, Your Lordship. No, Your Lordship. We took instruction from our client, Your Lordship. We do not wish to file any day subject to your convenience.
So and so appearing for the plaintiff. So and so appearing for the defendant. The plaintiff has filed an application under Order 13.
Yes, Your Lordship. Order 13A of the Commercial Code. Summary judgment application.
Under Order 13A, capital A of the Commercial Code Act, praying for summary judgment. Police. It is fine from the record by an order dated 10th of March 2025. The plaintiff is granted to file supplementary affidavit, but today when the matter is called, the net counsel for the plaintiff submit that they will not use any supplementary affidavit. Police. In view, police counsel for the plaintiff submit that the RG counsel is not in a position to appear before this court and prays for adjournment. In view of the submission made by the counsel for the plaintiff, let the matter appear. When your senior will be available?
Next week, Your Lordship, or any day, I'll leave it to Your Lordship.
Let the matter,
Next week.
let the matter appear on 7th May.
Grateful, Your Lordship.
Under the same heading. Under the heading adjourned. Next.
My lord, commercial suit, my lord, I am for the plaintiff, my lord. But they have filed an Order 7 Rule 11 application, my lord. My lord, the basic, if your lordship kindly go through their application before going to the plaint, my lord, basic is their allegation is relating to misjoinder. And they have filed an Order 7 Rule 11. So very short and precise, I can say, my lord, Order 7 Rule.
For the other side.
My lord, they are not appearing, my lord. And this is, my lord, not the first time, I believe.
Arvind Chakravarti.
But kindly, my lord. ঠিক আছে affidavit ready? Well, the other side has come, my lord.
I apologize, Your Lordship.
Yes.
Lordship, this was my application.
My lord, affidavit in opposition I have got ready, my lord, but let it be on record. I am not, because the plaint is enough. If your lordship kindly consider, perhaps, my lord,
what is the application for? Order 7 Rule 11?
Order 7 Rule 11. Lordship,
What is the ground?
I appear for the defendant numbers 4 and 5. My contention is that no cause of action has been disclosed against me. I am the director, the defendant number 4 and 5, they are the directors of the three companies.
Directors of the?
Of the three companies who happen to be the defendant numbers 1, 2, 3. Your Lordship, the principal transaction in effect has been with the defendant number 2, the defendant number 2 company. Your Lordship, they've implemented me in the suit as directors of the company in my personal capacity. It is on that front that I am moving this application. If it's so commenced to your lordship.
So you are the one of the director.
Your lordship, I'm one of the directors. I'm in no way
They're mastermind
personally.
in every.
I'm not personally involved in any of the transactions.
But you're the company. You're the director of the
All three
company.
companies.
Company, your lordship, I'm carrying decisions which show that as your lordship is, I need not embellish your lordship's wisdom with any judgment. Your lordship, lifting of the corporate will, it will only happen in cases of fraud. Personally, I cannot be impleaded in a suit, your lordship. Of course, I do understand, your lordship, the suit cannot be partially rejected. My other prayer is that in the alternative, let me be deleted from the area of part. Nothing else.
But where your prayer is Order 7 Rule 11.
Prayer is Order 7 Rule 11. That's why I'll press it under 151 if it commends to your lordship. Your lordship,
how it can
kindly. Lordship, that embargo I'm facing, I'm carrying a decision on the Delhi High Court, although that was in an Order 1 Rule 10 scenario. That is the problem. Your lordship will just allow me to, because no cause of action has been disclosed against me.
You do one thing. I am framing one issue on this.
Yes, my lord.
I will frame the issue
What?
whether the dependent number 3 for being the personal, having any personal liability to pay.
Yes. And lifting of bail, they are talking about it. That is also even a tribal issue. That cannot be
It is a
done.
tribal issue, but your lordship, that has to be
That's why if you
it does not disclose any particulars of fraud.
It's the best suggestion.
you file the
Got it, my
written
lord.
statement.
I beg your pardon, your lordship. The
file the
written
written
statement has been filed. That's what my instructions are. But written statement has been filed on behalf of defendant number 1 to 3.
1 to 3. No. Defend number 3 only. 1
only.
and 2.
Because 1
Time
and 2
120 days expired. May that chance be closed officially.
Your lordship, I am not representing the
4 and
defendant
5, you
number
have not filed the written statement.
4 and 5 because your lordship, there is no. We moved this application. No written statement has been.
So
filed.
120 days has
20 days has been
Then-
elapsed, your lordship.
the mastermind for all three companies. I have categorically pleaded in the plaint.
Maybe your lordship. Then your
Late
lordship
will-
will allow me to.
That's
move
why
my
that's
application.
why
Yes, but let it be an issue and
that will so then
it will be
that will
decided.
issue whether the
Why
defense
the
for 4 and 5
suit
but you have
is
not filed the
stalled for
written statement.
days after days and year after years?
Because your lordship, my learned senior must be correct. Your lordship, however, this is my limited prayer. That your lordship, now that I don't have the chance to file the written statement, and this is a commercial suit, so beyond 120 days, I don't stand any iota of the period of extension also, your lordship. So your lordship will just kindly allow me to move this application because I know your lordship will. Because your lordship, now personally the averments that I would like to make in my written statement, that opportunity I have lost.
No,
Your
no, my
lordship will
lord.
just
He
kindly
perhaps
take out the
doesn't know
plate.
he has filed the written statement.
Your lordship, that instruction.
Defend number 3, 4, 5 for everyone. Perhaps my learned friend doesn't
Yes,
know.
your lordship. I apologize, your lordship. 4 and 5 we filed the written statement on behalf of
Written
3, 4, 5.
statement
Then your lordship.
you take instruction otherwise.
Yes, your lordship will just give me a day's
If
time
you
to
file the
take
written
instruction.
statement,
Lordship.
you file the written statement, I will dispose of this. So the issue which you have raised in the application shall be decided during the trial by framing one additional issue whether the defendant number 4 and 5 being having the personal capacity is liable to pay any amount as prayed for by
Yes.
the plaintiff.
Your lordship,
And with the
I'll just be candid, your lordship. Should I had some more years of experience on my ground, I would have been able to take a decision. Let me just take instruction.
That's why I'm telling. That's why court is giving you time to
I
take
am
instruction.
extremely grateful. Extremely grateful.
Court is giving you
I
time to
will
take
take
instruction.
I'll come back
Yes,
tomorrow, your lordship.
And my lord, for 1 and 2, my lord, may the chance be closed because much after 120 days.
Where is that? Where is the
Read up
report?
please. It is in September and November, my lord. The writ of someone was.
We are only for 4 and
Date
5.
bolo? It deven. Lordship ke. Yes, my lord. September 23, 2024. At the middle, first
Third
column.
upon Gyan Sudha Das, Gyan Shyam Das, Ghanashyam Das. Who is Ghanashyam Das? Staff and authorized signatory for and behalf of the defendant 1, 2, 3, 4, and 5.
It is from sheriff office, my
One
lord.
duplicate, one is defendant number 1 and defendant number 3, 4, 5.
3, 4, 5 so DHA 1.
Delivered on 4th of
But the last column,
9th October for that. Yes,
right hand
both.
side, item delivered.
So who has not filed the written statement?
1 and 2. The
and 2 not filed.
Oh,
So
ठीक है, not filed, not filed.
have you obtained report?
Yes, my sheriff office my report. But the same thing I think I have handed over. And they have entered
No,
up.
whether they have entered appearance.
Yes, they had entered
Where is
appearance,
that?
I am told, and not filed.
Where is that?
I show you.
So appearing for the plaintiff, so appearing for the defendant number 4 and 5. None appears on behalf of the defendant number 1, 2, and 3.
120 days over. What I
It
do
is
want
the
consequential further.
defendant number 4 and 5 have filed an application being GA-COM 3 of 2025. Praying for rejection of the plaint. Full stop. The defendant number 3, 4.
Your Lordship, I am on behalf of 4 and 5. 3 is also the
yes.
company. Yes.
3, 4, 5 jointly filed WS, but the entered appearance.
It is fine from the record. A written statement on behalf of defendant number 3, 4, and 5 already filed after serving the copy to the learned counsel for the plaintiff, but no written statement is filed by the defendant number 1 and 2. Police counsel for the plaintiff has handed over a service report dated 18th December 2024, wherein it reveals that the writ of summons was served upon the defendant number 1, 2, 3, and 4 through the bailiff on 23rd of September 2024 and through postal services on 4/10/2024 upon the defendant number 4/10/2024 upon the defendant number 1 and 9/10/2024 upon the defendant number 2, 3, and 4. In spite of receipt of the writ of summons, the defendant number 1 and 2 have not filed the written statement. Thus, the CS Com 713 of 2024 be placed in the list of undefended suit against the defendant number 1 and 2. Full stop. The counsel for the defendant number 4 and 5 is for time to take instruction. According case is adjourned, let the matter appear when
Next week. Come back tomorrow if it's convenient for your Lordship.
24th.
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 Wednesday.
24 made me 23rd. I want
23rd.
23rd. Deeply obliged.
Extremely grateful to you.
Grateful.
But I am for the decree holder in this proceeding. The last order of 1st of August records that I need to serve them because we have served earlier also. They are not appearing. Now, there are two. What happened, there was a suit filed in this court which ended in the terms of settlement being filed. Now, in the terms of settlement, a money decree records the payment of money decree. They took time for a year's time to pay off. In the meantime, the terms of settlement records that 2 properties are given as a security. The terms of settlement records this decree passed. Now, at the end of the 10th month, we find that the judgment debtors may be dealing with those properties without paying a single penny for the last 10 months. We moved the executing court by saying, yes, it is a bit premature because my dues are only on the within 12 months. But still, if this sell away the secured property, then I am with security without a security. So, injunction on this Schedule A and B property, not to take third-party interest, was passed. A receiver was appointed to get inventory who are in possession and all. Receiver's report is on record. Now, we serve them. The judgment is not appearing. Now, when the receiver went to the property, then we discovered both the properties are joint family properties. The judgment debtors are co-owners. That's what they submitted. Now, that is the reason Mr. Rajesh Upadhyay appeared for the other co-owners. And he submitted that they will be seeking leave to file an affidavit before the court by saying the entire property, Schedule A, Schedule B property, the entire property does not belong to the judgment debtors, a portion may belong. Now, that is the leave obtained by the order of 1st August. It also recorded that on direction on us to serve once again. So, this we have done. There are 2 addresses of the judgment debtors. We have done all our item delivered. Now, this is affidavit of service. So, they all that. So,
how many contemners?
No, it is not a execution.
How many judgment debtors?
The judgment debtors are up to the respondents is 6. This is one, I must say, is 1, 2. Shormishta to boy. There are some ladies also, but let them file affidavit of asset for the time being. Yes, is the mother, and mother Shoma is the daughter-in-law, Shuranjan is the son, Shormishta is another daughter-in-law, Shujoy's son, Shobik's son. So, and the Mr. Upadhyay was appearing for the pro forma because the names of the pro forma was there in the suit, so it remained in the They say. Now, if they file affidavit of asset, so that we can understand that if they come to the box and we can.
When the notice was served.
No, notice was affidavit.
9th August 2024.
Yes. It is served on 9 August because thereafter, my lord, I change of determination and what I didn't.
Yes.
We can serve this order once again on them. My lord's today's order. We will serve. Because obviously August, today we are in April, I understand, my lord. So,
even though they have received the...
yes, they should have appointed an advocate. Yes. That's I keep on serving.
No, sir. So appearing for the decree holder. None appears on behalf of the judgment debtor. And the intervener. In terms of the order passed by this court dated 17 September 2024, the plaintiff has filed the decree holder has filed affidavit of service. Let the same be kept with the record. It is fine from the record, in spite of service of notice, none appears on behalf of the judgment debtors. The plaintiff has filed and the decree holder has filed the present execution application.
Terms of settlement is at page 77.
In terms of the compromise decree passed by this court dated 31st January.
No, 28th of August 2023. It's in the tabular 22nd. Sorry, sir. 22nd or 23rd. 23rd. It is the decree date.
Where is that?
The tabular statement. In the tabular statement is there and the decree is at page 94 or 93.
Dated 23rd August
2023. Tabular.
2023. In spite of service of notice, none appears on behalf of the judgment debtors. Accordingly, the judgment debtors are directed to file the affidavit of assets within a period of 3 weeks from the date of receipt of this order. The plaintiff is directed to serve the copy of this order to the judgment debtors and to file the affidavit of service on the next date fixed. This is the matter on 20 May 2020.
20th May. Another small request. The receiver has gone and taken symbolic possession. The receiver has pasted some small. Now what's happening? That has gone away. Obviously, that's the standard. That's next day. Has taken photographs are all here. Be that. Now, if we permitted the receiver to put a flex, a bigger one.
Let the affidavit of assets come. What they say. If it is not come, then I will again direct the receiver.
A flex will be a bigger.
Then you have to put the.
Yes, I will. Oblige.
I appear for the plaintiff decree holder, my lord. Your lordships were pleased to pass an decree on, my lord, 31st of January of this year, 2025. My lord, plaint for recovery of money against goods supplied and sold, my lord. My lord, it was undefended suit. The defendant, my lord, cross-examined my witness, and thereafter, upon considering all the evidence, my lord, your lordships passed the judgment on 31st of January 2025. That, my lord, is at page 17 of, my lord, my affidavit in support of the tabular statement. Now, the total amount, my lord, principal amount was 17,24,000.
Along with interest at 18%. From December 21 to till the realization. Not paid.
Not paid, my lord. Now, my lord, on 23rd of August 2023, your lordships were pleased to pass an order directing, my lord, deposit of 17,67,000. That order, my lord, is at page 11. Your lordship passed an order directing the defendant to deposit 17,67,000 at page 15. 17,67,248 to the credit of this suit, my lord. At page 15, my lord, about 6 lines from the top.
Correct. Yes, then.
So, my lord, now nothing has been paid. We have written a letter to the defendant, my lord. Nothing has been forthcoming. Now, my lord, we are praying for release of this money to my client, my lord.
It is deposited.
It is deposited, my lord. We have.
Where is the report?
My lord, actually, my lord, this is a precondition, my lord. At page 15, if your lordship reads further.
Okay, that's correct. Where is the report of the register? Then let the report be called from the register whether this amount is
very well, my lord.
There or not.
Yes, my lord. We'll have to. We don't have the report at the moment.
Correct.
Very well. Could it be short date, my lord? May I pray for a short date?
So and so appearing for the decree holder. The decree holders filed the present execution case for execution of the decree, judgment and decree passed by this court dated 31st of January 2025. Counsel for the decree holder submit that in spite of the judgment decree passed by this court, the judgment debtor one or
One, my lord. Only single debtor.
failed to pay the decretal amount along with the interest. Full list. The counsel for the plaintiff has drawn the attention of this court to the order dated order passed by this court dated 23rd of August 2023, wherein
Page 11 at
this
50.
court has directed the defendant to secure the principal sum of rupees 17,67,248 by way of cash security with the register original side of this court to the credit of the suit within 15 September 2023, failing which there shall be automatic decree for the principal of 17,67,248. Taking into consideration of the order passed by this court dated 23rd August 2025 and 2023, the register original side is directed to submit report whether the defendant has deposited the amount of rupees 17,67,248 in terms of the order dated 3rd August 2020. Let the said report be filed within 10 days from the receipt of this order. This is the matter on 8th of May 2025.
Grateful, my lord. Lord, I am appearing before the defendants, my lord. Lord, will be
For the
seeking
plaintiff, my lord.
Your Lordship, counsel for the defendants, defendant number 1, 2, and 3.
Lord, will be
Yes.
Your Lordship, the main counsel is as of right now on his legs in Delhi High Court. If possible, a short adjournment can be given. We can be
For
available.
the plaintiff.
I'm for the plaintiff, my lord.
Yes. Who has filed an application JCOM 1? What is the JCOM 1?
Application for injunction and passing off. We had already completed our submissions. This is regarding the SRMB TMT bars, your lordship.
That one?
Yes, your lordship. My learned friend was supposed to
Your
comment.
Lordship, it's part heard as of right now.
Correct. So when he will be available?
Your Lordship, a short date would suffice. We can appear on next Friday itself.
Lordship, this is the third time they're taking an adjournment.
Every time on the last occasion also the case was adjourned.
Your Lordship, just a short date. We will be appearing in this Friday itself. Just 4 days won't. It won't take much time, Your Lordship. Just coincidentally, the main counsel is on his legs.
As per the
in Delhi High Court, otherwise he would have appeared.
Sense opening for the defendant. As per the prayer.
And last occasion he has argued, Your Lordship.
Defendant. The case is adjourned. Let the matter appear on 25th April 2025.
Much obliged.
Be granted to this, your
Under the same idea.
Grateful.
Is clear for the defendant petitioner, my lord.
So for the plaintiff respondent, my lord.
Yes.
My lord, we were submitting, my lord, last occasion, my lord, the plaintiff had already completed. My lord, we'll kindly take, my lord's last order. We had handed over 2 judgments, my lord, which we seek to rely upon in support of our contention, my lord, that the right of the defendant to receive the writ of summons, my lord, cannot be waived, especially in the facts and circumstances of this case, where in open court, for the first time, an amended plaintiff is handed over to my learned advocate on record. On that very moment, it was not open for my learned advocate on record to waive issuance of writ of summons, and especially
Record says otherwise.
my lord, record,
You
my lord, the
received
report.
writ of summons, you've gone through
No,
the-
no.
all these things. And
No, my lord, the records say what the plaintiff has, my lord, 2 things, my lord. The plaintiff has shown that we had appeared in the mediation process. After institution of the suit, mediation process commenced pursuant to orders of court. We had appeared. My lord, we had indicated in our application, the only notice that was received by my client was by email, and that is disclosed, my lord. That is what the plaintiff relied upon. The email communication is when we first came to know that there is a mediation process and there is a suit that is pending before this honorable court. At that point of time, my lord, no steps were being taken in the suit itself. no service has today been shown at the registered office of the defendant, and my lord, the report has also been called for. My lord, has the report, my lord, by a prior order in this very application, my lord had called for a report. The report still shows writ of summons was attempted to be served. It has come back. That is there, my lord. If my lord takes the report of the department that was called for by my lord specifically, writ of summons was admittedly never served, and the pleading in the plaint itself. Yes, my lord.
Your advocate has appeared, and your advocate is telling that you are appearing, and then the writ
It
of
was
summons be dispensed with, and that has been dispensed with. Thereafter, you have taken several steps.
Yes.
Subsequently,
Yes.
one day you find that the address is not correct, then you file an application.
Yes, yes. It's for the Malad, to cut the matter short, Malad, it is for the ends of justice that we have filed this application on the ground that Malad, whatever Malad waiver of writ of summons perhaps my advocate on record Malad undertook on that date, but that is not in consonance with the provisions of the Act. Therefore, we have sought recalling of the order only to that extent. Malad will kindly take the two judgments that we seek to rely upon. Malad, our only contention is the right of the defendant to receive writ of summons under the Commercial Courts Act, as it has amended the CPC, Malad, is a valuable right. It is a valuable right and it is a non-derogable right. It cannot be waived, simpliciter by statement of my advocate on record. Well, that is our contention. If, my lord, we succeed there, we succeed, or else, my lord, will hold whatever, my lord. But we'll kindly take the two judgments that we've, my lord, handed over on the last occasion. 2023 SEC Online Delhi 358. We're also given copies to my learned friend. 2023, last occasion. Or if it's not there, I have a fresh copy. 2023 SEC Online Delhi 358. Mullah, will kindly take, I'll be relying upon Mullah, paragraph 19 to 25, 37, 38, and 43.
Paragraph
19 to 25, 37, and 38 are very important, Mullah, and 43.
Yes.
Mullah, paragraph 19, if Mullah has once. Paragraph 19. As per the petitioner, it was never served notice of summons for filing its written statement within 30 days in the period as stipulated under Order 8, Rule 1 of the CPC as amended by the Commercial Courts Act. As per the said provision, the defendant is to file writ of summons within a period of 30 days. However, the reason to be recorded in court and on payment of costs as the court deems fit, the defendant could be allowed to file his written statement beyond 30 days. Not important. Mullah will kindly then directly come to paragraph 21. Order 8, Rule 1 is set out. Paragraph 21. It is evident that the language employed in the proviso is restrictive and circumscribe the right of the defendant to necessarily file his written statement within 30 days. The proviso further curtails and restricts the inherent power of the court to grant extension of time beyond 30 days, extendable up to 120 days from the date of service of summons. The proviso simultaneously places a responsibility upon the court to record its reasons while granting extension of time to the defendant who may be in default in filing written statement within the stipulated period of 30 days. Besides, the proviso is couched in a negative language and stipulates that the right to file written statement beyond 120 days by the defendant is automatically extinguished by operation of law. Thus, there is no iota of doubt that Order 8, Rule 1, read with the proviso as amended by virtue of the Commercial Courts Act, is prohibitive as well as restrictive in its nature and in contradistinction to Order 8, Rule 1 of CPC 1908 as applicable to ordinary suits. The wisdom of the legislature in drafting such a strict and rigorous provision is not far to see, in that commercial suits should not be lingering in courts for years and ought to be resolved at the earliest. This obviously would be in the commercial interest of the nation. Well, I will kindly then directly come to paragraph 37. This is just to show, my lord, that the provision is restrictive in nature and it is rigorous. Therefore, the right of my client to receive a writ of summons cannot be waived. 37. This court is therefore of the opinion that it is imperative to direct the civil courts adjudicating commercial suits while issuing summons to the defendant to necessarily incorporate the endorsement the defendant should file written statement of defense within 30 days from the date of receipt / service of the summons on the notice of summons it is also apparent from a plain and harmonious reading of all the aforesaid three provisions of the CPC that the service of summons itself is a very important procedural step to be undertaken by the court, and there cannot be any laxity insofar as the commercial suits are concerned. 38. Moreover, once this court has concluded that so far as the commercial suits are concerned, the failure in strictly following the procedural steps as stipulated in Order 5, Rule 1, that relates to summons, issuance of summons, cannot be to the detriment of the defendant. The logical conclusion would be that the same are mandatory in nature. So, my lord, our contention, as is shown from this judgment, the issuance of writ of summons to my client is.
So as per your submission, the submission made from the bar has no value. Once the advocate will come and say, I will accept the writ of summons, and subsequently other advocate will come and file an application. No, it was misunderstanding, has accepted that after going through this. Whether this judgment say that?
No, of course not, my lord. What we are trying to say, my lord, will kindly appreciate.
Order 5, you have dispensed with by accepting the writ of summons before
My lord,
the court.
the writ of
and the
summons
court
was-
has recorded that.
My lord.
And it is not on the very second day or very 1 month. You have subsequently filed after 2 months, 2 years.
My lord, only one thing, my lord, here. Writ of summons was not handed over in
Sorry,
court, my
sir.
lord.
I am clearly telling that against the advocate's submission, if the order is passed and you are filing an application, court is very against that. Once advocate has admitted the plaint before this court, dispensed with that, now you are coming with the amendment has not been served. That is after 2 years.
No, my lord, perhaps, my lord, I'm being led
Sorry.
by Mr. Dutt, my lord. If my lord grants leave to me.
My lord, I can, my lord, appreciate, my lord, your lordship's anxiety because, my lord,
No, please,
precious
please,
time
please,
has
please,
gone.
please,
Precious
please appreciate. You all persons are the officers of the court.
I know.
And on your submissions, the court is recording the statement and passing an order. One advocate had appeared stated it is to be dispensed with, rightly or wrongly. It has been dispensed with. And immediately you have not come forward on the very second day, third day, fourth day. After this long time you have come, and in the meantime several water has been flown.
My lord, I appreciate, my lord, what is troubling your lordship. My lord, may I just indicate two things. My lord, my learned friend, as well as your lordships, hesitate to recall the order is on the ground that your authorized representative has received a document acknowledging the fact that there has been a service of writ of summons. Now, and on that basis also, my learned friend is proceeding on the basis and on the principles of Order 9, Rule 13. My lord, there is a world of difference so far as law is concerned, but factually, my lord, first factually address your lordship. My lord, it need not be argued before your lordship that a plaintiff's duty, if he files a suit, is to serve. Service has two processes. One is lodging a writ of summons by taking out with the department and effecting it to be served in two modes, one by post, one through the court.
Yeah.
Now, my lord, here is a case where, my lord, if your lordship sees the report that your lordship has called for from the register, your lordship will find that the plaintiff was aware of the fact that the writ of summons which he has taken out in the suit to be served on the defendant has come back unserved. He knew it. So, that's number one. Kindly, my lord, lordship has called for the report. The report of the register will show that.
Yes.
So on that date, the plaintiff knew that he has sued the defendant on the wrong address, and therefore he made an amendment.
Yes.
Which, my lord, my counsel at that point of said it can be allowed. Now, my lord, I had pointed out to your lordship in that amendment application, he has himself acknowledged the fact. Amendment application. he has, sorry.
Amendment application.
Yes, my lord, he has filed an application. My learned friend is relying on the order. I had placed that application for amendment. This question. What's the order? Your lordship will find the amendment application.
Amendment kind.
No, my lord, I showed it, and my lord, on that basis, your lordship put a question, because there also in paragraph 9 and 10, if I'm not wrong, he acknowledges the fact that I carry on business.
Next with the application.
Yeah. Extra follow. No, paragraph trouble. Will it kindly come to the petition? Page 85, it starts.
Yes.
Kindly come to page 93, paragraph 9.
Yes. Immediately after the defendant taken expeditious steps to change the name in the registered office, and as on the name of the defendant is to change CLD. Yes.
And the amendment sought is only for the purpose of changing the address in the cost title. And only the name, not even the address. Come to page 15, my lord. This is the amendment plate.
Yes.
My lord, your lordship will notice, my lord, that being aware of the fact, in the one breath he says that I have my office in Bombay, and on the other breath, my lord, he tries to represent that I have an office in Shakespeare. Having knowledge of the fact that the writ of summons attempted to be served has come back unserved.
Yes.
Now, the question is, if you have amended the plaint, law requires you to take out a fresh writ of summons, which you have never taken out. And when you wanted to serve,
So this amendment,
my lord,
was allowed.
Yes.
When, by which order?
By your lordship's order, my lord, come up with
Not at their consent.
yes,
They only seek to change
Yes,
the
yes,
name.
I will come.
my understanding trying to say that you were not aware of the fact that his summons has come back unserved.
They have only pleaded that they have a registered office.
Brother,
Yes, yes, yes.
brother. My lord, this amendment was allowed.
By which order the amendment
My
was
lord,
allowed?
give me a moment. Order for page 100 to 104. 104. Chapter down. Abhi nahi gadi hai.
18th May it was allowed.
24, 29. Just a minute. 24 July 20.
No, no. The
18th.
by
I'm sorry.
18th May. 18th May. And when the writ of summons was dispensed with?
Never thereafter.
Huh?
Never thereafter the writ of summons was published.
No.
So the writ of summons even today is in the wrong address.
When the order was
So the order which I'm
dispensing on the
seeking
order?
recalling is
Dispensing?
17th August at 105. Your Lordship has been very careful to record defendant has accepted the notice of the amended
105.
105.
Yes.
Now, my lord, my learned friend is relying upon Order 9, Rule 13 principles. Kindly take Order 9, Rule 13 once.
Yes.
My lord, in any case in which a decree is passed ex parte, here, my lord, we are not at that stage. He is relying on the principle, not on the section. So, my lord, we are at a stage where the suit has not commenced, but he proceeds on the basis that this principle applies. Decree is passed ex parte against the defendant. He may apply to the court by which the decree was passed for an order to set it aside. And if he satisfies the court that the summons was not duly served. So, my lord, here is a case where the summons was taken out at the correct address, but it was not duly served. So, my lord, in this case, or that he was prevented by sufficient cause from appearing when the court was called upon hearing, the court shall make an order setting aside the decree as against him upon such terms as to cause payment into court or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit. He is on proviso 2. Provided that further no court shall set aside a decree passed ex parte merely on the ground that there was an irregularity in the service of writ of summons, not on the taking out of writ of summons. Here we have a case where the summons was not been taken out in the proper form. After the plaint was amended, the right procedure, my lord, had I not consented to, what did I dispense with? I dispensed with the service of writ of summons. I didn't dispense with his obligation to take out a writ of summons. I'll give you a very lordship, my lord, why it is so mandatory. Suppose, my lord, this suit has been a suit for eviction. He sues me on the suit premises in a wrong address. Court passes a decree. I having knowledge of the fact that there is a suit, I don't contest it. How does he execute it? Because the schedule would be wrong, the address is wrong. So, my lord, the mandatory provision of law, which even Order 9, Rule 13 does not dispense with, is taking out a writ of summons. And here is a plaintiff who is aware of the fact that the summons which he has taken out is erroneous because he has attempted to serve, both have come back to him. Now, my lord, may I ask myself this question? Had I moved this application for amendment and I had told your lordship that attempt to serve the writ of summons has come back and notices attempted to be served at the address is coming back, the first thing the lordship would have said that if you are not attempting to serve and it's coming back, make a publication. That is what the law says. He doesn't bring it to your lordship's notice.
That's correct. That's correct.
So, my lord, if he is the plaintiff who is, my lord, not coming clean, he is filed a suit, he would expect somebody to come and defend it. To defend it, law requires him to serve, take out and serve. Now, my lord, suppose I know, my lord, that is what is troubling your lordship, that I know and I had acquiesced in the conduct of the suit. That is what is troubling your lordship. Now, my lord, suppose I do not say anything. That is also acquiescence. Silence is acquiescence. As I told your lordship, my lord, if I can show, if your court comes to the conclusion, even at the final hearing, that summons was not served on the defendant, and that's the reason the defendant is not appearing. Would the court proceed on the basis and say, no, even then, I'll pass a decree because he is aware of the fact that the suit is in the...
That is the problem here. You have also taken a technicalities. You have also taken a technicalities because you had appeared before the court. Correct. You had the knowledge the writ of summons was not served upon you, but you hope.
No, my lord, I could not have known because I appeared from the mediation stage, and the mediation is by mail to the
suit also. And if the court finds, okay, they have filed an application for amendment was allowed with the consent of the parties. Okay, with regard to the amendment, not the address, only the name they have mentioned. Now you are taking the plea as per the case, as per their case also, the address is also changed. Mumbai instead of Kolkata. But they have not changed amendment the address of the defendant, only they have changed the name of the defendant. And you had appeared and you have accepted the writ of summons, and this court has dispensed with the issuance of the writ of summons as you have accepted that.
My lord.
So now you are telling that he has not amended the address of the defendant and he has not the writ of summons. So that's why the defendant had no knowledge with regard to the writ of summons. So what for the advocate appeared and taken the made a submission and dispensed with the writ of summons?
My lord, generally, my lord.
If it is an ex parte, without this the court has passed an ex parte, then your submission could have been taken into consideration.
That a representation was made by a member of the bar that yes, I am ready to take service. Why should I not hold that promise or that representation to him and say that you are liable for it?
And it is not your case because he has not been advised.
No.
It is not your case. It has not been advised.
My lord, generally, a service of writ of summons is dispensed with only for the purpose of expediting the suit. Had my lord, she had not been there, then the usual process would have followed.
Correct.
Now, the fact that she wanted to expedite the suit and was kind enough to receive and say that, no, you don't have to serve me, this representation proceeds on the basis that the service which you are trying to make is an honest and bona fide service. Very well. I am here. My client has authorized me to represent. You have taken out a writ of summons. You don't have the trouble of serving it. It will take some time. I am here. I am accepting it. But as I say, my lord, at the cost of repetition, I don't give up my right to a summons being taken out. What I give up is the right that you don't have to put it in the post, give it to me. I am here to take it on behalf of my client. Yes. So receipt of the writ of summons does not dispense with the obligation of the plaintiff to first take out a writ of summons.
What further remains if the party appeared to the advocate and the advocate accept? What further remains for lodging of the writ of summons?
My lord, that as I told you, lordship, my lord, suppose, my lord, I accept the writ of summons today, and thereafter, my lord, I don't appear in an eviction suit. So when the court is passing a decree for eviction or in any suit, my lord, the court has to be conscious of the fact that it is a defendant against whom he is passing a decree, not against a third party. So, my lord, any ex parte decree, the first thing the court observes that the writ of summons has been duly served. Now, my lord, if this had been the case over here, my lord, the writ of summons, it would transpire at an order 9, rule 13 says that it was not duly served. Number one. Number two is, my lord, I can accept a fact that I carry on address at both places and at certain given point of time to play foul with the court, I am taking this defense. But it is not coming out from me, it is coming out from his own efforts. His own plaint shows that he could not serve it. So it is not a defendant who is trying to run away from the court to delay the proceedings.
Yes.
Kindly take page 37, paragraph 79 of the plaint.
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 You
I'm sorry. Application. Recognition application sheet.
79
Yes.
within
Yes, sir.
jurisdiction. Yes.
এটা কি দেখাচ্ছিস? এটা কি প্লেন?
Plain. This is part of plain.
Yes, this is part of plain. Plainটি তো বলছি, তুই না বলছিস। Page 79 page is part of the plain, page 37 of the petition.
Correct.
The defendant is within the jurisdiction of this honorable court and is carrying on business from Shakespeare Court, flat number so and so within the jurisdiction. Accordingly, this honorable court has jurisdiction to adjudicate the suit. Then, however, the letter dated 17 January 2020 for some reason was not received at Shakespeare's Court, flat number such and such Kolkata, but was received at an office situated in Circus Avenue, which is an office of a group company. So his own plain statement shows that he is not been able to serve. Now, my lord, I tell your lordship, my lord, in any other case, a suit which has not started, my lord, any plaintiff will come and say that very well, I'm serving him at the correct address, let him file his written statement. Now, two things is troubling the why is my learned friend so tooth and nail opposing when he knows that that is not the correct address? I'll tell your lordship why. Because he has obtained the jurisdiction of this court based on this address. Otherwise, this court does not have jurisdiction.
That's a this.
So therefore, at the clause 12 leave stage,
as the statement which is in the amendment application,
there also he says that Bombay.
'93. 93 paragraph 9.
My lord.
Defendant had taken expeditious steps to change its name and registered address in 9th of December 2019. Correct. And as per this plaint, when the cause of action arose?
My lord, as per him, the cause of action arose in
Refuted the claim on January 2020.
16.
17 January 2020. No, paragraph, page 37, paragraph 77.
So that is, my lord, his cause of action.
That's why.
So he was aware of that. My lord, there is no doubt of the fact. And my lord, your lordship will find. Now, my lord, kindly come to the cause title of the plaint. I can appreciate this.
And when the suit was filed?
Suit was filed in 2020.